はい、皆さん、こんにちは。米国特許セミナーパテントターミノロジーです。このシリーズでは、特許用語、表現などをできるだけわかりやすく解説しています。講師は、米国特許弁護士であるブライアン・エプスタインさんです。今回は、何々に基づいて、何々に従って、何々するとについて見ていきたいと思います。これらは、if や when などの、条件節を使って訳されることもあれば、upon や in response to, based on などを使って訳されることもあります。これらについてブライアンさんにご解説いただきます。Okay, Brian さん、please share your thoughts on conditions precedent such as if and when, otherwise upon, in response to, based on.
Sure, it's a tall order. So to kind of give a sense of some of these latter phrases, we kind of have to start at the beginning, and that's with this concept of conditions precedent. And the famous one is the use of the word if. So, for example, a claim might recite, controller X determines whether valve Y is open or closed if a detection signal is received from sensor Z. So, according to case law, this claim is properly rejected at the USPTO if the prior art discloses that controller X determines whether valve Y is open or closed. Okay. They're not looking at this portion. They're not necessarily looking at this portion about receiving the detection signal. And so basically, the detection signal is not given patentable weight. Technically, the patentable weight given to the if statement is a little complex. Basically, if the prior art discloses the detection signal is received from sensor Z, okay, if that portion is true, then the prior art also must disclose that the controller X determines whether valve Y is open or closed. Okay, so basically this if portion, if the if portion is true, then the preceding portion, the determination, also must be true if this reference is used to anticipate or render obvious the claimed subject matter. However, if the prior art does not disclose that the detection signal is received from sensor Z, then the claim can still be anticipated by the controller X determination alone. Okay. We only look at that, we only have an issue if the detection signal is received. If there's no description of a detection signal, if the detection signal is not received, then the prior art is sufficient to anticipate the claim based only on that first portion, on the determination of the valve. And so it basically seems like the PTAB, so this is comes from the Patent Trial and Appeal Board, the PTAB, PTAB. So it seems like the PTAB is trying to distinguish the word if from the phrase only if, right? They're trying to suggest that applicants mean only if. But, if applicants, I wouldn't use only if. So I don't recommend that you use only if. And so maybe there has to be some other solution to this problem. And so this rule comes from this case called Ex parte Schulhauser from 2016. And so, again, when I started the first slide, I said that this is the law at the USPTO under broadest reasonable interpretation. So is this the rule during litigation as well? And it's kind of an undecided question, as far as I could tell. The Schulhauser decision is based on two unpublished Federal Circuit opinions. So there is some precedent at the Federal Circuit to adopt this approach. But I've read the opinions. I think they're very fact specific. I think the fact that they are unpublished also suggests that these are not very, that the Federal Circuit did not intend to make a blanket rule about this, that if is different than only if. And so, at the very least, the Federal Circuit view is not clear, right? They haven't published a decision on this specific point. And ultimately, I do believe that the Federal Circuit will reverse the Patent Trial and Appeal Board. But the issue with that, if you know the US legal system, is that this issue first must reach the Federal Circuit, right? So someone has to be brave enough or have enough money at stake to get the bad decision from the USPTO and then appeal it to the Federal Circuit and say, you know, Federal Circuit, it looks like the USPTO is interpreting if more broadly than you believe. Could you please reverse them? And then the Federal Circuit, I think they would, under the right circumstances, they would reverse the PTAB. But I don't expect people to do that. And the second issue as well is that examiners have been interpreting the term if broadly for many years before Schulhauser. And so many patent attorneys have already stopped using the term if, or if they did, they knew that they were trying to get a very broad claim, right? There's nothing wrong with trying to get a broad claim as long as you know that it can be a little bit risky and maybe the examiner is going to disagree and that you'll have to correct the issue. So what a lot of patent attorneys started doing was using the term when. So, okay, Brian, what about the phrase controller X determines when a detection signal is received? So we don't really have a clear decision about condition precedent on this, but my opinion is that this would likely be interpreted as a condition precedent as well. So again, at the USPTO, this probably is not that examiners can't give it the interpretation that applicants want, right? They certainly can. And again, sometimes I'll try to get that scope for my applicant with the idea that, you know, we've got a broad claim now and, you know, maybe this is good enough for licensing, or I'll need a narrower dependent claim if we go to litigation, right? So maybe the accused infringer will try to invalidate the patent as too broad based on the use of the term when, and so I'll have a dependent claim that recites something more narrow, and we'll come to that in a moment. And so one of the issues is that examiners interpret the term when as after a lot of the time, and that's also quite broad. And this is a very typical type of interpretation that comes out during examiner interviews. And so, you know, we have to find another option to try and get the scope that applicants intend so that they can successfully overcome the prior art. So, okay, well, what about controller X determines upon receipt of a detection signal? This is a translation of Suruto. I did some research recently, and both dictionary.com and Macmillan Dictionary define upon as immediately after. Honestly, I'm pretty sure that upon was not always defined this way. I previously used it based on other definitions. I would not have used immediately after. I mean, that to me is far too narrow. So I'm sure I saw a different definition that I thought was acceptable, but the dictionaries I saw recently seem to have this different definition, and so maybe the definitions changed over time, which is part of the issue of relying on dictionaries. So the issue with upon then, if it means immediately after, is that we might have enforcement concerns. Particularly if the accused infringer has a small delay, right? So maybe in our example of determining the status of the valve upon receipt of a detection signal, maybe this controller performs a small subroutine. The accused infringer's controller performs a small subroutine before making the determination, or maybe it just waits, 2 cycles to make sure that there's no subsequent follow-up from the detection signal. Whatever it is, it's not immediately after. And so therefore, if we have this narrow definition of upon, of suruto, then that's not a useful claim for our applicants. And so far, all of our alternatives seem to focus on the timing. It maybe not for if, but for when certainly has a timing aspect, and upon has a timing aspect. And there must be some other way to claim cause and effect, right? And so this is where we start getting into in response to. This is a good example of what I said previously about a narrower dependent claim. If the independent claim recites when, maybe we have a dependent claim that recites in response to or something. Well, generally, people agree that in response to creates structural cause and effect relationship between 2 operations, right? Like if you have a flow chart, you can see the link between the 2 blocks of the flow chart that has, that gives structure to the operations. But not everyone agrees. If we go to, I've certainly interviewed many cases. Most examiners agree. I talk about this with other U.S. patent attorneys. We all kind of agree. But recently I had an examiner who disagreed, and some U.S. patent attorneys also interpret the phrase in response to mean immediately after. And, we just spent the previous slide explaining why we want to avoid that phrase. And so, although historically I've favored in response to, recently I've started to drift away from it unless my examiner insists on it. Like, I don't mind using it, but it's not my preference. It's not my first choice. Of course, if a client wants to use it, I'm happy. But if the client lets me choose, I'll usually try something else. So what will Brian choose? So these days I like based on. This is, I guess, typically the translation chosen from ni motozuite or ni shitagate. And so this phrase seems to satisfy everyone. Examiners, sometimes you have to get more narrow than based on, but examiners understand what interpretation you want from it, right? There must be some basis there. U.S. patent attorneys agree that it's not, something that has to be immediately after. There's got to be, again, some sort of structural cause and effect aspect to it. So the issue here, because again, there's no clear answers. There's very rarely a clear answer in U.S. patent law. Some practitioners like to read the phrase only into this recitation of based on, right? So they'll say that the language at the top of this slide means that controller X makes this determination based only on or only based on a detection signal, right? It can't be based on anything else. I don't necessarily agree. I think that, especially in a comprising claim, that's not necessarily true. But it's not a lot of work to address that concern. And so I suggest consider using the phrase at least partially based on, or, there's a lot of variations on this. at least based in part on, stuff like that. There's some variations, but that seems to be a very broad way that addresses a lot of different concerns and still creates the kind of structural cause and effect relationship that most applicants are looking for.
はい。ブライアンさんありがとうございました。今回は何々に基づいて、何々に従って、何々するとについて解説いただきました。今回はこれで以上になります。ご質問や使ってほしいトピックなどがありましたら、YouTube のコメント欄に書いていただくか、スライド最後に記載のメールアドレスまでお気軽にご連絡ください。では本日もありがとうございました。失礼します。
ありがとうございました。